Judgment in the matter of National Union of Rail, Maritime and Transport Workers and another against Tyne and Weir Passenger Transport Executive trading as Nexus.
Lady Simler will provide a summary of the judgment in this case.
This case is about rectification. The appeal raises questions about whether it is possible to rectify the written record of a collective agreement which is not a legally enforceable contract, and whether contracts of employment which incorporate the terms of such a collective agreement can be rectified. It also raises questions about the appropriate parties to such a claim, and whether an employment tribunal has the power to decide it. The facts can be summarised shortly. The employer, Tyne and Weir Passenger Transport Executive, referred to as Nexus, operates the Tyne and Weir Metro. In 2012, a collective agreement was reached between Nexus and two independent trade unions, who were recognised as entitled to conduct collective bargaining on behalf of the employees. The unions are the National Union of Rail, Maritime and Transport Workers and Unite, together referred to as the unions. The agreement was recorded in a letter stating that Nexus, the employer, would consolidate a pre-existing entitlement referred to as a productivity bonus into the basic pay of the employees, giving them a higher basic salary. The general rule is that collective agreements negotiated between employers and unions are not intended to be legally enforceable. That rule applies here. However, the employment contracts between Nexus and its employees contain a clause which incorporates the terms of collective agreements reached between Nexus and the unions as terms of their employment contracts. A dispute arose about the meaning of the letter agreement, and in 2015 a group of employees brought a claim against Nexus in the employment tribunal. The employees argued that they had been underpaid because, on a proper interpretation of the letter agreement, the effect of consolidating the productivity bonus into basic pay was also to increase shift allowances, which are calculated by reference to basic pay. Nexus denied that that was the correct interpretation of the letter agreement, but the employment tribunal upheld the claim, adjourning consideration of the question of remedy. Nexus appealed, but its appeals were ultimately unsuccessful. No remedy hearing took place in those proceedings because they were stayed, together with other similar proceedings, pending the outcome of these present proceedings. In 2020, Nexus commenced these present proceedings in the High Court, seeking rectification of the letter agreement. Rectification is a remedy which puts the record straight by correcting a mistake in a document that records a transaction. The proceedings were brought against the unions and not against Nexus employees. Nexus claims that the letter agreement as interpreted by the courts in the employment tribunal proceedings does not accurately record the common subjective intention of Nexus and the unions that the consolidation of the productivity bonus into basic pay would not increase the shift allowances. Alternatively, Nexus claims that the letter agreement should be rectified because of a mistake made by Nexus to the knowledge of the unions in recording what was agreed. The unions applied to have the claim struck out. The High Court rejected that application, but on appeal, the Court of Appeal ruled in favour of the unions and dismissed Nexus's claim. Nexus now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal. Lord Legate and I give the judgment of the court with which the other justices agree. We discuss the nature and role of rectification and the sorts of documents to which it has been applied, and having done that, we address the first issue, which is which contract needed to be the target of any rectification order. On that question, the Court of Appeal considered that in seeking to have the letter agreement, which is not legally enforceable, rectified, Nexus aimed at the wrong target. It should have sought rectification of the individual contracts of employment with its employees, which incorporate the terms of that letter agreement. Our judgment disagrees with that conclusion because the employment contracts have exactly the effect which they were intended to have of incorporating the terms of any relevant collective agreement between Nexus and the unions. If any mistake was made, it was made by Nexus and the unions in failing accurately to record the terms of the collective agreement. It is therefore the letter agreement recording the agreement which needs to be rectified. The next issue we discuss is whether the letter agreement is rectifiable. On this question, the Court of Appeal considered that the fact that a collective agreement is legally unenforceable is a barrier to its rectification. We disagree with that conclusion. The reason why a court will not normally rectify a document recording a legally unenforceable agreement is that it would be futile, because rectifying the document will not affect any legal rights or obligations. Here, although the letter agreement is not itself legally enforceable, rectifying it would indirectly alter legal rights and obligations between Nexus and the employees into whose contracts the terms of the letter agreement are incorporated. Accordingly, if a mistake has been made in recording the letter agreement, it can be rectified. The third issue we address is who are the proper defendants to a rectification claim. On this question, we agree with the Court of Appeal that Nexus has brought its claim for rectification of the letter agreement against the wrong defendants. We conclude that proceeding against the unions and not the employees is improper for two reasons. First, there is no legal dispute between Nexus and the unions as to the existence or extent of any legal right between them. Secondly, Nexus is asking the courts to make an order which would alter the legal rights of employees, but without giving them any opportunity to be heard. That is contrary to the most basic principle of procedural justice. In our view, there is no significant practical barrier to bringing a claim for rectification of the letter agreement against employees whose legal rights are affected by the claim. Even if there were, it couldn't justify departing from the basic legal principle that the proper parties to proceedings are those whose legal rights will be affected by the court's decision. The fourth issue we address is whether the Employment Tribunal could have made an order for rectification of the letter agreement in the Employment Tribunal proceedings. We hold that an Employment Tribunal does not have power to make an order for rectification. However, we consider that the issue of rectification could have been raised by Nexus as a defence in the Employment Tribunal proceedings, and if a relevant mistake was shown, the letter agreement could have been treated as if it had been rectified for the purpose of determining the parties' legal rights without the need to make a formal order for rectification. This principle applies in the civil courts, and there's no reason why it should not apply in proceedings in an employment tribunal. Finally, we address the question whether Nexus can raise rectification now against the claimants in the employment tribunal proceedings. On this question, like the Court of Appeal, we consider that it is not open to Nexus to raise the issue of rectification in those proceedings at a remedies hearing. To do so would be inconsistent with the decision already made in those proceedings that the claimant's complaints are well-founded. It would also be an abuse of process if Nexus were to seek to undo the result of those proceedings in any fresh action which would deprive those claimants of their victory in the employment tribunal.